Thank you. Please be seated.
Good morning. We're here for oral argument in case number 1 CACB 19-0350, Sean and Jody Coleman et al. Versus John Brock Amon and Jean Marie Amon, defendants. Counsel, just very quickly, I know you're quite familiar with these arguments, but just a reminder, please identify yourselves at the beginning of your arguments and as well as your clients. Each of you have 20 minutes, of course, and Mr. Abney, you should watch the clock to reserve as much time as you'd like for rebuttal. Also, we've read the briefs and have discussed this case in conference. With that, Mr. Abney, you may proceed.
Thank you, Your Honor. May it please the Court, I'm here today representing the appellants. My co-counsel here also, Adam Stadnicki and Lucky Slomsky. Once in a while, well, actually fairly often, you have a case where there's a precedent that really matters a lot. And in this case, it's Barsima versus Susong.
I'm sorry, Mr. Abney, could you restate that? I'm not hearing you very well, actually.
Just to add that. Yeah, there you go.
You know, maybe I've been watching Outlander, and I think I'm picking up a Scottish burr, which is a very soft kind of accent. So if you'd be forgiven me, Your Honor, I appreciate
So you're
it.
an Outlander kind of guy.
Yes, I am now.
All right.
I've made it through about halfway through season 3, and I think it's coming out my ears. But in any event, that's to the side. Barsima versus Susong, I believe, is the case that matters most. You can find it at 156 Arizona 309. And in that case, the legislature did much what it did here, trying to give a favor to the healthcare profession by passing a statute that prohibited admitting into evidence any evidence that someone has been covered by the state medical malpractice insurance plan or have financial interest in it. And the Arizona Supreme Court said there's a big problem with this, namely that there's a separation of powers issue, and we have the right to make rules of procedure and evidence. Article 3 is the separation of powers article. Very short article, but independent. There's nothing else in Article 3. There's no subsections or anything else. It's that important that the framers wanted to devote a specific article to it. And then in Article 6, Section 5, Subpart 5, it delegates to the state constitution the right to make rules of procedure, and the state Supreme Court has said that means rules of evidence as well. And here you have a direct conflict, as you had in Barsima, between a rule that the legislature has created that contradicts rules of common law evidence and indeed procedural rules that the state Supreme Court has adopted. In Barsima, it was Rule 411, and here it's the rules concerning the admission of evidence about an admission or inconsistent statements, the ability to impeach and to attack credibility. All of those common law rules of evidence and procedural rules of evidence are contradicted by ARS Section 122605.
Counsel, let me jump in here on separation of powers. So are you contending that based on Barsima, because the linchpin there for me is that there was a complete prohibition. The statute completely preempted the rule. Okay, it was a complete conflict between the statute and the rule, correct, in the Barsima case. Is it your contention that there's the same type of conflict here? You say there's a conflict, but is it a partial conflict or is it a 100% conflict? In other words, this is a little long-winded, but I'm just going to call them apology-related statements. Under what conditions in your mind can apology-related statements come in after the statute was adopted? What is allowed? And you can feel free to raise a hypothetical. I know you're contending they should have come in as impeachment here, but is it limited to impeachment, or is it even impeachment? Because isn't that just making an end run around the purpose of the statute?
Well, it depends what the doctor says. If here the doctor says, I'm sorry, and I'm basically, what did he say? I'm sorry, and I feel like I've let you down. And then later says, no, I never said that. I never said I said I was sorry. I never said that I let you down. So then you'd have impeachment right there. It's not an end run around the statute. It's a separate sort of thing going on.
But how would you bring that in? You put the nose of the camel in the tent, and then the camel's going to come in.
Well, sure, if the camel is foolish enough to contradict itself, which is what this doctor did. Instead of sticking honestly, we say, to what he had said earlier, he changed what he said, and then you can use impeachment that way.
When during trial should that have come out? Like when Dr. Amon said, "Look, I didn't breach the standard of care." Would that be the time to make? Because I don't see in the record what troubles me. I don't see like an offer of proof, like a shout out saying, "Judge, this is where we have to bring this up." Well, we now have an expert, Dr. Amon, who's contradicting himself, and here's the evidence. We want to have her testify, or I want to ask the question of whether he's being truthful about his apology.
Okay. Well,
so is that where it should have come in?
That would be a good place to do it. However, you didn't need to, because in dealing with the motion in limine on this subject, in opposing that, my colleagues in its index of record 263 at page 4, lines 3-11, they actually said they made the argument we can use this to impeach and to attack credibility. Now, if you do that in a motion in limine procedure, you don't have to repeat yourself at trial. That's the whole purpose of motion in limine, is to streamline the process.
That's Rule 103B, is that what you're referring to?
If you're talking about impeachment?
No, talking about once you raise it, you don't have to raise it.
Yes, Your Honor. Yeah, and case law to go with it. So that deals with that. However, in a sense, that is a bit of a sideshow. In Barsema, there was also a way to lie. It wasn't a complete preemption. It was a way to elide around that by showing bias and prejudice under Rule 411. So that was a sideline, though, also to the main problem. The main problem is you've got a collision between Article 3 and Article 6, Section 5, Subpart 5, and this statute. You just can't let the legislature say, okay, there's certain things that they're not going to be admissible, that were admissible under the old common law, and that are admissible under the present common law and the procedural rules that the state Supreme Court has created. That's the big problem.
Let's say we agree with you on that it should have been allowed to be used for impeachment and to attack credibility. Why reversible error? What's the prejudice here?
This was a long trial.
I know.
And an expensive,
Yeah.
costly trial, and much depends naturally on who you believe. And here you've got a doctor changing his story, for one thing. And here you've got a doctor who made statements that fit within this apology statute. He made statements that would deal with responsibility and liability. And we call it an apology law, but it's far more than that. It deals with things like responsibility and liability. He admitted it. Reasonable jurors could conclude he admitted it. And here they didn't get the chance to decide. They didn't get the full evidence of what actually happened. That's the problem with statutes like this. When the legislature comes in and tries to give a special favor to certain groups, it makes them immune from the search for truth, which is why we're here, after all. I mean, you look behind you. This is a temple.
Counsel, 43 states, by my count, as of yesterday, that have this law, some form of this apology law. Are you aware of any of those 43 states that have invalidated the law based upon separation of powers? I don't know if other constitutions have special laws. I haven't been able to drill down that far. In other words, I'm looking for a case. I'm looking for some authority where other courts at least have said this is really problematic and this cannot hold up.
There's the Utah case I cited, which is not exactly on point. Cases exactly on point, I'm not aware of. But I am aware of the Constitution, Article 3, and I'm aware of Article 6, Section 5, Subpart 5, and I'm aware of Barsema. And we fit within the constitutional language, and we fit within Barsema.
Ask a question on this. So, when you go to the separation of powers argument, isn't it the Seisinger case that directs us? You have to look at if there's a procedural element to it versus a substantive element to it, the statute, and where it's procedural, our rules will govern, but where it's substantive, we defer to the legislature. Isn't that the case that we have to use to analyze this? Or am I mistaken?
I would never say that any
Oh,
judge is
well,
mistaken.
my
But-
ego is not so big.
Okay, well, that's good. Yes, then you are mistaken, Your Honor. This is a procedural rule, like the rule in Barsema, the same sort of thing where the legislature is stepping in and saying, we get to decide what the evidence rules are, the procedural rules. And you can't do it under Barsema. You can't do it under Article 3. Our state constitution is unique. There's very few that have this separation of powers article in it, of any state constitution. It's also unique in the delegation of the rulemaking authority to the Supreme Court. Other states may truckle into the legislature, into special interest groups, but our state is not supposed to do that. And that's why Barsema was decided the way it was decided, and why this court should decide along the same lines as Barsema. Now, I also made the argument about special laws, which I've made repeatedly at this court, and I will continue to make them, because this is a special
Until we
law.
agree with you.
Until somebody agrees with me, Your Honor.
Counsel, so did I, and I was reversed.
Well-
So, in the Gallardo case.
But-
So I'm very familiar with special laws, but I wanted to ask you about that because the Constitution says, it says that no special law shall be made where, quote, changing rules of evidence,
Right.
end quote. Again, I'll come back. Are you anywhere of any case law that construes that specific phrase?
Not in there. No, I'm not, Your Honor. But I'm also aware of the principle that we should apply the plain language of the Constitution. We shouldn't adorn it. We shouldn't water it down. And this next subclause of Article 4, Part 2, Section 1913 talks about granting special and exclusive privileges and immunities and franchises to any corporation, association, or individual, which is another problem with this law. It grants a special privilege to certain members of the healthcare profession.
Do you have standing to assert that?
Yes, it was asserted below.
No, do you have standing? I mean, you're
I'm just, well, as my clients,
legal standing to assert. Why?
they're citizens of the state of Arizona, and I'm the lawyer representing them, so
But
we all have
wouldn't
standing.
somebody else need to come in and say, hey, another profession would need to say, no, look, we want to be the lawyers. And lawyers, we want to be able to apologize to our clients when we mess up, or architects or engineers. Nobody's telling. I was just wondering if you needed standing. It hasn't been raised by the defense.
Okay. We have standing. No, we don't need to say that we're in a class that has been injured, because I'm a lawyer and there's no apology statute for me, or if I were an architect.
But isn't that the point of what you're complaining about? In essence,
Exactly
it applies
right.
to one particular class.
Because the legislature has singled out a very powerful class, by the way, very wealthy class, and says, we're going to give you a special privilege. And here it is, have a nice day.
True, but all of the legislature, or all defense has to show is that there's a rational basis for the enactment.
That has been much of the case law in the past, and I submit to you that is wrong. Because our duty is to follow the Constitution the way it's written. We all took an oath to protect and defend the state Constitution, and I believe it's as written. And as written, this is just not allowable. You can't change the rules of evidence, and you can't give away these special privileges to select classes simply because that's the political thing to do. That's why this kind of constitutional protection was provided in the Constitution. And of course, as I mentioned in my briefing, it goes back to the territorial days when the territorial legislatures were notorious for giving special favors to select groups, railroads, mining companies, or whatever it might be. And this was designed to stop giving these kinds of special favors. And I will continue to argue that until somebody, as I said, agrees. This court may not, but maybe if it goes further, the Supreme Court will.
Let's turn back to separation of powers for a minute. Back to this procedural versus substantive. Because if I understand Seisinger correctly, if we conclude and agree with you that there is a direct conflict between the statute and the rule of evidence, then we move to the second prong, which is whether it's substantive or procedural. Why doesn't the legislature have the right to say, look, from now on, doctors, you have the right, privilege, whatever label you want to put on it, to make these statements, and you will not be held accountable for those statements in a court of law. He will not be, they cannot be used against you.
Because that's a procedural rule. And in fact, if you look at the statute itself,
but Seisinger, the majority really goes out of its way to build this case of why the rule there was substantive. How is that different?
well,
The rule there was about expert witnesses, right? So of 702.
yeah, but it was not it was the structure for the expert witnesses. And here we're dealing with a rule dealing with the admission of evidence. And in fact, if you look at the end of the statute, it says inadmissible as evidence, or of an admission of liability, or as evidence of an admission against interest. It's talking about evidence. That's what the statute's all about. 122605 is inadmissible as evidence of an admission of liability, or as evidence of an admission against liability. That's what they're concerned with, evidence. They created an evidence rule that is in direct conflict with the Arizona Rules of Evidence and with the Arizona common law on this subject. If I may reserve my time.
Sure. Thank you.
Oh, I stand on the other arguments in the brief, by the way.
Ms. Gilbride.
Good morning, Your Honors. Eileen Gilbride for the defendant, Dr. Amon, I'm told. And with me is trial counsel Scott Holden. I really don't have a lot to add to our brief on the apology statute. I guess we can skip over the wisdom of the statute. The legislature has the right and made a very reasonable determination that as a matter of public policy, this statute is a good idea. So I don't think we need to get into the argument that plaintiffs raised that apologies should be admissible. The statute is constitutional. I'll get to the separation of powers since that seems to be the area of interest here. Your Honor is absolutely right.
Can you back? Before we get to that,
okay.
Let's talk about statutory construction, plain language. So the legislature says that these types of apology-related statements, again, I'll use that term, is inadmissible as evidence of admission of liability or as an evidence of admission against interest. Those two things. Why did the legislature include those two phrases and not, well, two questions. Why didn't they stop before they included that phrase? Or alternatively, why, without stopping and putting those two phrases, don't we presume there's something else? In other words, there's room for some other evidence to come in.
I think there's room under this statute for the evidence to come in the right circumstance.
Please help us understand.
Give us an example.
I'm not sure what that example would be. But what I was anticipating you asking me is, would we be here if Dr. Amon had said, oh my God, I was negligent, I did this, I'm at fault, would this be a different case? At least in that case, you might have a situation where the assertion or the statement was relevant to liability. Here, it's not even relevant to liability. When he says, I feel like I've let you down.
I've let you down?
I feel like. It's a statement of his substantive feeling like I've let you down, and I've cited cases in our brief.
How would he have let these folks down? He did nothing wrong, and he testified to that.
That's true. I mean, but he still felt that way. I mean, if you're sick, I still feel sorry that you're sick. That doesn't mean I caused you to be sick.
Sorry is one thing, but letting you down.
And he said, I'm sorry, I feel like that. I mean, that's his substantive statement. And if you look at the cases we cited in our brief, a feeling of substantive, I'm sorry, or however he wants to express his substantive feeling is not a substitute for he fell below the standard of care.
What about the other example that the father claims that he asked the question, if we had done a C-section, would we have a different outcome? Would we be here in this situation? And the doctor said, it would be different. What about that?
Okay, well, that was not the subject of the motion in limine or the arguments below. That may have been admissible on a causation issue, but that certainly hasn't been briefed, and it wasn't what they argued below should have been admissible. So, I mean, that's a different thing. I don't think that's I'm not sure that comes within the statute, the language of the statute.
Because that would not have the generality you're talking about earlier.
I'm not sure it's a statement of whatever the language is that the statute goes into, a
Well,
remorse or
I mean, I
condolence.
I might disagree with you on that. I think this statute is very broadly worded and says it refers to responsibility, liability. And he's talking to the patient. I mean, the patient or relative of the patient. But
I think you could
regardless,
argue.
I thought it was part of the motion in limine. Actually, I could be wrong. I thought it was brought up in the motion in limine. But regardless, so do you?
It was Mrs. Coleman's statement
Right.
that was part. That was
Right. Yes.
the subject
It said
of
that
the
her husband had said that,
motion.
yes.
Motion in limine.
So, moving into separation of powers, because
Yes.
is it your contention that there is no, under Seisinger, then there is not a conflict, a direct conflict between
Correct.
the statute? How so?
Because what counsel is saying it causes the conflict is with the hearsay rules. And the hearsay rule says these kinds of things are not hearsay.
Well,
It doesn't say,
Specifically, I think they're contending, although it could have been expressed more directly in the opening brief, I agree, but they're contesting that it's a direct conflict with the opposing party's statement under Rule 802,
okay, so
801D2.
these are two completely different issues. If he's talking about the deposition, where he said, no, I didn't say that, or I don't remember saying that, okay, there are two different issues. One issue has to do with impeaching Dr. Amon with his deposition testimony, where he
Right.
said, I didn't say that, or I don't remember saying that. That's a completely different issue than, can we use the substantive statement, her statement, not his statement?
Yeah.
Can we use her statement, this is what he told me, as an admission or to impeach him? He has never changed his story. He had never said in his deposition, first I said it, then I didn't say it. That has never been an inconsistency in his testimony. What they wanted to do was use her testimony, Mrs. Coleman's testimony, this is what he told me, to impeach him, his statement that I met the standard of care.
Right. But
Okay,
pre-statute, why wouldn't that come in? Pre-statute, 2004, why wouldn't that
Because
statement come in?
his statement, and maybe you
Not
just...
his statement, her statement.
her statement about what he said.
Yes.
Her statement about what he said, I'm sorry and I feel like I've let you down, is not, according to the cases that I cited, and there are cases and the law review articles that say that is not an assertion that he fell below the standard of care. It is a subjective assertion of his feeling of remorse and condolence and commiseration with her. That's why I started out saying, if he had said, I'm negligent, I did something wrong, I'm at fault, then you have a conflict that doesn't exist here. Here, we don't have a conflict, so we never get to the, is it procedural, is it substantive? We just don't have a conflict. And we don't have a conflict with the hearsay rules, because the hearsay rule says these statements are not inadmissible hearsay. The rule doesn't say these statements are admissible on liability. All the hearsay rule says is you don't have a hearsay objection to these statements.
So you turn to two things, relevance and 403.
Exactly. That's exactly
that's
right.
the rules.
That
And
is exactly right.
Relevance is a pretty low bar.
Well, if the judge could have said, I think this is just not relevant. I don't think it's relevant. The cases, the law review articles I've cited say it's not relevant. There are no cases that he has cited, that counsel has cited, saying that assert subjective feelings of, condolence are statements on the standard of care.
And yet, if you and I get into a car accident at an intersection and I jump out and say, oh my heavens, I'm so sorry, it was all my fault. Coming in or not?
I'm sorry, maybe not. It was all my fault. I guess so. I mean,
To show
but we're
what?
not.
To show what? That doesn't prove that I breached the standard of care. It doesn't show that
But
I was driving too fast.
I don't have to show that you were violated a standard of care in a car accident case. You
Correct.
do have to show in a medical malpractice case that
What do you have to show then? Do you have to show I was negligent?
That's true. But if you say I'm at fault, I mean, that is evidence of negligence. I don't need an expert to say that.
I think that the cases, what's confusing me here is I think the cases you have cited, and correct me if I'm wrong, and I won't be offended, but is that those cases say that a mere apology is not enough. Those cases have said, they've said, look, apology doesn't, a mere apology by a doctor, that's not good enough to show breach of the standard of care. But I don't read those cases as saying that's inadmissible evidence. You see the difference there? I mean, tell me why I'm wrong there.
And so, are you saying that under the common law,
Yeah, under
that
the
it would be admissible?
Exactly. I'm saying like.
That's okay. It's
I mean, you
okay.
can ask somebody what you had for breakfast, and if that's relevant, that's coming in. That's a statement by the
Right.
other party. What did you have for breakfast this morning? Before you operate on the patient. Now,
Okay.
right? That if the judge says that's relevant,
Okay.
that's coming in.
Okay. So, but the fact that it's relevant is we still have the legislature's public policy determination that for other reasons.
Right. So that's good. Give me your best argument as to why. Assume that there's a direct conflict. Okay. Assume that I think there's a direct conflict. Now help me understand why it's substantive versus procedural. That this is purely substantive.
Because it's in the nature of a privilege for the doctor, just like the physician-patient privilege to speak to speak without hesitation, to not to allow free speech between the patient and the doctor without worries about, where is that going to get me into trouble. That's what the legislature wanted to do, was to encourage the free flow of communication between doctor and patient. It's like a privilege for the doctor to be able to do that, just like the patient has a privilege to speak freely to the physician, and we don't want to put our fingers in that pie. We want to keep that sacrosanct. That's why it's in the nature of a privilege. I don't think we have to get there. I'm going with your hypothetical that there's an actual conflict.
Sure.
But even if there is, then we can get to the procedural substantive.
And if there is a direct conflict, the Seisinger case, is that the analysis?
Right, that's the analysis that we use. If there's a conflict, then you go to the substantive versus procedural, and of course it was held to be substantive in the Seisinger case. I'm very familiar with that
What you're
one.
saying rings, it sounds compelling to me. However, but then I go back to what is the plain language of this statute, and it goes back to the exceptions that might be applicable here. Like if a doctor actually does admit, straight up fault. Yes, I was negligent. Actually, I overslept. Actually, I was hungover this morning. I came in and did the surgery anyway. Egregious facts. But then you're saying, but then that substance goes away?
Well, then we have a different conversation with the trial judge. Then the conversation with the trial judge is...
It's just outside the privilege, is what your argument would be. That type of conduct would fall outside of this privilege that the legislature might fall outside the privilege and would therefore be admissible.
No, I don't think so. I think if you're...
But I thought you said earlier that there could be some circumstances in which a doctor's admission of negligence could come in the right circumstances.
Under this statute, under the language of this statute, where under my theory that there's no conflict, that we're not getting into the substantive procedural. I didn't think we have to go there. But if we have to go there, okay, let's call it a privilege, and then it's not admissible. If we're not even getting to the conflict and not getting to procedural versus substantive, then and you have an egregious situation like you were talking about, then I think the conversation with the trial judge is different. The trial judge would say, well, I'm not sure. This seems to be relevant. It seems to, you conflicted by saying I'm at fault, and now you're saying I met the standard of care. That might be an impeachment situation. And then you have to go to Rule 403, and then you have to see, am I going to go with the legislature's public policy? I don't know. This is an entirely different case than what we have here. I'll speak for a few minutes on the special law. This statute is not a special law. Changing rules of evidence might be a category of special laws, but it's not the analysis. As Your Honor noted, the only analysis is whether there's a rational relationship to a legitimate legislative objective, and of course there is. The classification includes all similarly situated members, and it does. It's all healthcare providers. That's a classification that's been upheld before in Governell versus Lieberman and in Baker versus University Physicians. And the classification is elastic. People can come in and out of it. It's not a classification of all people who were insured by MICA in 2010, which is not an inelastic classification.
What do you think the framers of the Constitution meant when they said no local or special laws shall be enacted changing rules of evidence?
Well,
That's pretty black and white.
I don't think this. I mean, there are lots of statutes that survive special law scrutiny, such as that seem to change rules of evidence for public policy, for substantive public policy.
But are you aware of any cases that have actually taken that phrase head on?
I couldn't tell you right now.
Okay.
I'm not aware off the top of my head, but you have subsequent remedial measures, and you have all kinds of statutes that find for good public policy reasons not to admit those items of evidence, and they're not unconstitutional. As Your Honor noted, there are 40 however many states with these kinds of laws, and there's not one case out there that has held any of these statutes unconstitutional. Counsel spoke about a Utah case that he cited. That came down before Utah had their statute, and it did not hold the statute unconstitutional. So I just think he's way out of left field here, and the analysis doesn't hold through. If you would like me to speak about the evidentiary issues, I will. Otherwise, if you have any other questions. On Dr. Amon's impeachment, he didn't change his story. They're trying to impeach him with deposition testimony that was not before the trial judge. Yes, they said in their motion in limine that he testified XYZ in his deposition, but the deposition pages were not before the trial judge when he made his ruling on the motion in limine. That's been waived. On the Dr. Elliott, do you have a question?
No.
On that? Okay. On the Dr. Elliott impeachment, there's no evidence that impeaching Dr. Elliott with the heart rate tracing would have made a swit of difference in the outcome in this case. If you want to know the backstory to that, it's in our response to the motion for a new trial. Plaintiff's counsel tried to gin up this fake defense and then kept trying to get to it, and the trial judge would not have any of it, and that's what that all went to. There's no abuse of discretion on that score. Unless you have any other questions, I'll.
Just one more.
Yeah.
And you may have touched on this early on, but under what scenario would Dr. Amon's alleged statements come on? Under what scenario could they come on?
I guess what I really meant to say was there may be a situation that's not this situation, that is not in front of us, where the trial judge would have to examine, is this really conflicting? I met the standard of care, I didn't meet the standard of care. Am I going to allow this impeachment evidence? And in that situation, even though I think the judge would have to make a 403 decision and would have to examine the purpose of the statute, that's certainly a difficult, decision that the trial judge would have to make. If I was a trial judge, I'd probably go with the statute and say, yes, he may have contradicted himself, but the purpose and the purpose of the statute is clear. The legislature's intent is clear. But that's a different scenario that we don't have here, that I don't think we don't have to deal with.
Thank you. If I may, Judge Williams, you had raised a point about the question the husband had asked. I have one question for you. If we would have stayed with the C-section, would this have happened? And Dr. Amon, according to the husband, put his head down and he said no. That's at page 26 of our opening brief. There's a direct citation to the record where that happened. So we put it in the opening brief as part of the argument about what Dr. Amon was admitting. Yeah, yes, that was. What was in the response to the motion limine? It's IR 195. So it's in there as an exhibit and as evidence.
Counsel, Ms. Gilbride was addressing the by not being heard.
Yeah.
That's a unique thing. That when something's obtuse, we don't want, I'm so sorry this happened. What happened? He's not admitting anything. He's just saying he's sorry it happened. Would the other example, and I was waiting for someone to raise this issue, would the other example of saying, would this have happened if you had been the operating position? Whatever the appropriate term is.
Right.
Is that a distinction? Is that specific enough that under any scenario it should have come in as
It's specific and it's strong, but as Judge Brown was indicating in the auto accident, if you get out after the accident, and I'll modify this slightly, I'm sorry, I'm a good driver, I feel like I let you down. That would be admissible. It's an admission against the party opponent. And if you later on you say, no, I didn't say that, it's an inconsistent statement. Here there's an inconsistency going on because at the deposition, where did I put that? Again on page 26 of the opening brief, and this is a quote out of the opening brief. In his deposition several years after Baby Lane's delivery, Dr. Amon denied that he had told Jody Coleman that he was sorry and felt like he'd let her down. And there's a direct citation to where that appears. So this is open game for impeachment and for an attack on credibility. But when you say, I admit, if all you said was I'm sorry, or add some adjectives and adverbs, I'm very sorry, I'm extremely sorry, this is terrible, statements of condolence and simple apology like that, you're sort of in the fog on the moor, if I may use that example. And you need to get into the clear light, and you move into the clear light because he says that he felt like he had let us down. And when you're talking about letting somebody down, you're saying, well, I could have done better. I did something bad. I did something wrong. Reasonable jurors may or may not give that a lot of weight. But in a case of this complexity and this length, you never know where the tipping point is.
Well, but clearly, if you say this would not have happened, the one thing we're here and we're upset about and we are trying to figure out how this could have happened would never have happened if I had been the one doing the work.
Wouldn't that be a glorious world if people would be that honest and straightforward?
But isn't that effectively what was said?
In effect, I believe in shorthand, that's what he was saying. I felt like I let you down.
Is there a difference then between that and what we have in this case?
What we have in this case is enough to get over the barrier and say that this is a statement of liability, a statement of responsibility.
And he was sorry?
I don't know about I'm sorry. It would depend on how you do it, the circumstances. I suppose that would be a jury question, and one of the foggier jury questions. But this is clear, I believe. If you say you let somebody down, you're admitting that you're liable and you're responsible. There's a great song in White Christmas called "Gee, I Wish You Were Back in the Army." I don't know if you remember that great, wonderful song. Anyway, some days.
I hate to admit that I do.
Some days I feel like I wish you were back in the Navy, because if you screwed something up in the Navy, you did something wrong, you admitted it, you tried to fix it, and then you faced the punishment. And this statute takes you way out of the Navy. You can admit you did something wrong, you never face the music for it, and you just go on with your life. That's not the way the law is supposed to be. It's a search for the truth. And here, the statute is a direct roadblock to the search for the truth. I believe it's an unconstitutional statute as well, but you can stand on the edge of the statute and say, well, hold on, this is still admissible, because the statute at the end is very specific as to what it's dealing with. Inadmissibility is evidence of an admission of liability or is evidence of an admission against interest. That doesn't mean you can't use it for a statement in proper circumstances for impeachment or an attack on credibility. And I submit to the court we have the proper circumstances here. If you're uncomfortable holding it unconstitutional, which I hope you're not, you can still say that this would be admissible for impeachment and credibility. And it matters. In a case like this, it matters a lot. And I have run out of time. Thank you very much.
Thanks, Ken.
All right, thank you, counsel, both for your very helpful arguments this morning. The court will take this matter under advisement and issue a decision in due course. We stand adjourned.